are exploring Public Universities Bill, threats to academic freedom. You've been following the conversation that has ensued since that document was released by government. And government has been defending its intention to pass the Public University Law and is preparing to lay the draft proposal in Parliament. A lot of issues have come up, but what is the purpose for this bill? And government has been explaining that. It says the 48-page document will provide the procedure for the establishment of public universities, principles of management of public universities, and it says that the document will still provide the legal status of public universities, the procedure for financing public universities and administration and supervision of activities of public universities. That's the explanation we are getting from government. But you know, in the last few hours, there's been so much resistance from lecturers who this bill, university lecturers who this bill will be affecting. And one of the resistance, it says, first, the document has already, been met with fierce resistance. It says, they have described the document as a threat to academic freedom. Specifically, clauses 5 to 12 of the bill is where the lecturers have issues with. And we'll be going into those clauses when the conversation kickstarts. But clause 5 seeks to reduce the composition of the public university councils from the average of 15 to 9. And the lecturers say this will lead to increased government representation on the council and restricts the academia from criticizing government. This is very critical, and we are going to be interrogating this tonight. Now, let's look at clause 11, and that mandates the council to establish standing or ad hoc committee and assign to the committee's functions that the council considers appropriate. But the lecturers complain the bill is silent on who makes up this committee. This is also very critical and is fundamental. It's one of the questions we'll also be interrogating on PM Express tonight. Now, the university lecturers say government will be setting a dangerous precedent if it goes ahead with this bill. It didn't end there. Now, government has responded to the lecturers' complaints, and they say the proposed law is only to allow the input of lecturers before the bill is presented to Parliament. So lecturers really do not have any beef to question it at this moment. Again, the lecturers respond to that, and they say, and Professor Jampo, for instance, describes the move of crafting the bill without consultation and now asking them to input into the bill as an insult, and we'll be looking at why. It didn't end there, because the minority in Parliament have also been speaking on this bill. And first, the minority has vowed to resist the bill if it is laid in Parliament, which government intends to do in in the coming days. And it says, in its current state, it will resist it. Now, it is backing the protest by the academia that it is an attempt to stifle academic freedom. That is why the minority says when this comes to Parliament, they will resist it with all force. Now, the question we're asking tonight is that, is the Public University Bill a threat to academic freedom? That's the question we're asking tonight. Is the Public University Bill a threat to academic freedom? And we'll be doing so much more on this topic. We've got all the answers for the questions bugging your mind. And my guest in the studio tonight is Dr. Samuel Nkuban. He is the Vice President of UTAG at the University of Ghana, Legon. And then he'll also be joined by Dr. Clement Apak, who is MP for Busa and also the Deputy Ranking Member on the Education Committee in Parliament. I must say that we had an agreement with the PRO of the Education Ministry. Few minutes into coming to the studio, I had a call from the PRO of the Ministry of Communication that he's had calls from above that he should not be on the show. So we do not know where the call is coming from, but what we know is that government is running away from discussing this issue and explaining to Ghanaians why they are taking this decision. We'll get into the conversation shortly after this break. welcome back to PM Express. We're looking at the Public Universities Bill and we're asking the question, is it a threat to academic freedom? And in the studio with me already seated, Samuel Nkoban, Vice President of the University Teachers Association, UTAG at the University of Ghana, Legon. We'll also be joined shortly by Dr. Clement Apak, who is a Deputy Ranking Member on the Education Committee in Parliament. And of course, Vincent Asifua is Communications Director of the Education Ministry. He was supposed to join us, and then a few minutes into the studio, he called to say that he's had order from above not to be on the show. And of course, we don't know which rank or where that call is coming from. So, Dr. Nkoman, good to see you. But we've been told that the proposed draft bill on public universities will, among other things, provide the procedure for the establishment of public universities, principles of management of public universities, and also even provide legal status of public universities. This isn't bad. Why are you resisting it?
Well, we are of the opinion that already exists, and the acts establishing the various universities as independent universities cater for all of these grammar that is being churned out under the circumstance. And so what it is that the establishment of each university comes with responsibility in relation to what government expects the university to deliver. And so, for example, if you have a University of Ghana or you have a University of Science and Technology, it comes with its statutes, it comes with its legal backing, spelling out specifically what the university established is supposed to be doing. And so to say that you are generalizing the act which governs the operations of all of the universities within the country seems to be the case that you expect University of Ghana to act and be the same as University of Science and Technology, or that you want it to be as University of Health and Allied Health Sciences. And indeed, these are universities established specifically for specific purposes, considering the development needs of our country. And so we expect that what the system that exists, where as and when the need arises for us to tackle a particular development need of the country, particularly so when we require the establishment of a university to cater for that, then of course we can be thinking of a bill to set up that university rather than to say that we are generalizing and having a common universities bill. That's we don't see how that pans out, particularly when you consider some of the provisions that are in there.
But they say the current laws governing universities is quite old and has outlived its purpose. You don't agree?
Well, of course, I would agree that many of them may be, but of course, we also undergo the process of revision. And so, University of Ghana, for example, the law that established University of Ghana was revised not too long ago. I think around the year 2008, there was a revision. And so there's a new act that holds what University of Ghana ought to be doing. And so, as and when the need arises, as and when we feel that the dynamics of our development needs are changing and that we need to modify the situation for the universities to meet that, then of course, revisions can be made. And of course, that is why we have a parliament. And so it is not the case that the laws that were passed in since we started the constitution are the same laws that are, as and when the need arises, revisions come, amendments come, and what have you. And so it should be the same applying to the acts that establish the universities. And many of them have undergone revision.
So let's get into your concerns, particularly. Which parts of this bill do you have qualms with, or is it the bill in its entirety that you really are not happy about?
Well, many aspects, and we believe that, as is said by many other stakeholders so far, we expect that there should be some consultation with stakeholders, major stakeholders such as UTAG. Of course, once it comes to the universities and the people who teach in the universities should matter. And so we expected that at least, even in the process of drafting the bill, UTAG will be consulted. Unfortunately, that didn't happen. We also expected, of course, that before it got to this point where it's now public knowledge, at least, major stakeholders should have a fair idea what this was all about. Beyond that, there are specific provisions within the draft bill, as we choose to call it. It's a draft bill.
It's a draft bill for now.
So there are specific provisions that we are uncomfortable with. For example, the reduction in the number of members of council. Currently, we have 15. Out of the 15, in some of the universities, the government appointees are 5.
Okay.
To reduce that to 9 would mean that government has 5 appointees and other stakeholders would have 4, okay, which makes government majority stakeholder in the entire
council.
Yeah, and the council is the highest decision-making body of the university.
Right.
Impliedly, government has control of the governing body, and so that in itself is a questionable issue. Then we have also some elements that seek to suggest that some of the reps, particularly coming from the worker unions, should be represented or should be appointed by government. That also doesn't sit well with us. Okay. Also, one of the critical matters in the bill is in section 23(2), where it states that the Minister of Education has responsibility to approve engagements by the universities with academic or non-academic institutions, so that if the University of Ghana, for example, needs to go into partnership with another institution or with a financial institution in an attempt to ensure that at least what we require to be a university worthy of a world class, the implication is that it needs approval from the minister. And we think that many of these things that are going to gag the universities and not allow for them to function as independent, autonomous bodies. And of course, the implication is also that you look at the definition of academic freedom in the bill, and it talks about freedom of expression by lecturers. We don't think that is what academic freedom means. Okay. And so if it is just about freedom of expression by lecturers, that doesn't constitute sufficiently what we should consider as academic freedom. Our ability to engage in certain categories of research and also the manner in which we disseminate the information and all of that matter when it comes to academic freedom. And we think that the definition, for example, of academic freedom is narrow, it's kind of myopic and limited in the sense that is currently presented. You
say you were not consulted. Government says you were consulted. Indeed, I heard the communications director of the Education Ministry saying that even UDS and UHAS have also even brought in their input, which they expect all other universities to do. So why you weren't consulted?
Well, UTAG as a body, I can say for certain that we were not. But what has happened is that I have information that the vice chancellors of all the universities were given copies of the draft bill. The vice chancellors were required to submit some kind of a response or some of their comments on the bill to government. Some of the vice chancellors provided this information to their heads of departments, and they expected some returns from the heads of departments. Many of those have happened, and it's likely that universities as corporate, with the vice chancellors as chief executives, may have presented a certain opinion to government, but UTAG as an entity, as a major stakeholder nationwide, we also have had the document from some informal sources, and we are yet to meet as a body to digest the provisions and make our position as UTAG known to government. Okay. And so as we sit, we do not have, UTAG has not taken a key position on this, but we are concerned with some of the provisions.
But I know UTAG is represented on the council, I mean the University Council as it stands now. I mean with the old laws, UTAG is represented. Yes. How many members of UTAG are supposed to be on the council?
Generally, it's only the president of UTAG of each of the campuses that is supposed to be represented on the University Council. Aside that, the students have a representation at the SRC level and then at the GRASAC level, the Graduate Students Association of Ghana. So the president of SRC, the president of UTAG, the president of SRC are supposed to be part of the decision making when it comes to the University Council. Right. In addition to that, we have other categories of worker unions. Convocation is supposed to have 2 elected members. Okay. This bill seeks to reduce that to 1. And of the 2 elected members, we have one who is supposed to be a senior member academic, meaning also a lecturer, and then another representing other categories of workers. And so, and all of these are critical stakeholders when it comes to the management of the university. And to take away their voices from the university councils, for example, we think is unfair. Okay. And it is not in the right taste when it comes to decision making. So that if government has 5 representatives and the other worker unions and stakeholders have only 4, including the fact that the National Council for Tertiary Education is going to be represented, despite it has no voting rights in accordance with the new draft bill, then of course you realize that if it comes to a vote, and all 5 members of the of government appointees are present, then you can take a decision that goes other way. Yeah. And so it looks as though it is an intentional act that is meant to kind of take away the autonomy, take away the freedom, take away the reality of what is on the ground in terms of the decisions that ought to be taken by the universities. Okay,
let me bring in Dr. Clement Apak. He's MP for Bosa South, and he's also the deputy ranking member on the Education Committee of Parliament. Good evening to you. Great to have you, Honorable.
Hello.
Mr. Apak, you are on PM Express. Now, Parliament, minority in Parliament certainly is unhappy with this bill. And what do you want government? You want government to actually withdraw that bill, or not even, just to stay away from the bill?
First of all, let me say good evening to you and to viewers, and to indicate that while we have not formally received this in Parliament or as members of the Education Committee, we have also become aware of the existence of a draft bill known as the Public Universities Bill. Now, we became aware of this through information that was put out by Professor Jampo, whereupon he indicated that he was part of a group which was giving the opportunity to look at what government is seeking to bring forward. Since that happened, we've been able to get a hold of the document in circulation. And in all honesty, reading it over and knowing the context within which higher institutions of learning are supposed to function clearly indicates to us that it seeks to be a bill that wants to give a lot more control of the management of our institutions of higher learning to the government of the day, or if you like, to the executive. And I believe that is a very wrong approach. Whatever the case may be, whatever the motivations may be, I believe that what we have currently in existence within the context of all of the public universities, their statutes and the acts that establish them are fully capable of ensuring the efficient management of our higher institutions of learning. And you see, it is very worrisome, because when you look at the rearrangement of the council that is being proposed to be a blanket system that is going to run across all of the campuses of the public universities, it becomes clear that the stakeholders who compose the academic institutions are going to lose control over what happens on those academic institutions. The government appointees are going to be dominant. And once the government appointees are dominant in terms of the 9 being proposed, what that then means is that whatever the government of the day or the executive wants to happen in as far as the management and other activities on the university campuses are concerned, the numbers of the government appointees would always ensure that what government wants, government will get. Now, remember that it is usually the council that confirms and or appoints a vice-chancellor. After all the processes of the selection committee, the winnowing down, and the public fora have been held by the selected candidates, the one of the two persons who will be shortlisted eventually would be appointed by the governing council. Therefore, if government appointees are going to be the dominant number on the governing council, it presupposes that whoever government wants to become the vice-chancellor then becomes the vice-chancellor and not the person that the university community would want to be vice-chancellor. Now, the other change that we see in this proposed bill, if true, is that council is now going to be given the power to appoint the chancellor. Now, think about it again, that in the current arrangement of 9 council members dominated by government appointees, appointing the chancellor, that also then reduces the autonomy and the stature of the chancellor to be able to hold council itself accountable if and when it becomes necessary. So when you put all of this together, and you also see components giving the Minister for Education the right to have a say in the governance of our universities, even proposing policy directives. Clearly, our institutions of higher learning, if what we have seen is what is going to come to Parliament, the way it is, cannot be independent. And that is why we don't think that if what we have seen is anything to go by, it is justified or it is needful. We truly believe that it is a needless proposal. It is not necessary at this time. We truly cannot find any reasons to justify why we need such an act when what is already in place for all of the universities have the capacities to work effectively if we would allow them to function without political interference.
Doc,
most of the problems we currently face,
Doc, do you agree?
whether it was the case of KNUST.
Do you agree that
yes,
most of the laws that govern the public universities are outmoded and perhaps have outlived their purpose? And what would you have had government done in this situation?
Well, first of all, I don't believe that the laws governing the universities are outmoded.
Some of them.
Because if they were, the university communities themselves would be the people advocating for change. Now, remember that you are dealing with those who train people like you and me. You are dealing with professors and PhD holders. These are persons who are connected to the rest of their colleagues across the globe. They know cutting-edge programs, technologies, and methods of teaching and learning. So it cannot be true that it is because the current laws are outmoded. If you actually go through this proposal and you compare it to what is already in existence in all of our public institutions, I would argue that what government is seeking to do is actually going to be a panacea for a lot more acrimony and unrest on campus. Because truly, there is no way the unions on the various campuses are going to accept this proposal that henceforth there will be only one union representative. I mean, so who is going to represent the unions? FUSAG, UTAG, TEU? And the proposal is that one union would choose one person to represent all unions in a rotational manner to do with the life cycle of every council. I mean, where does this happen? Why would government want to reduce the number of independent stakeholders on council? And the answer is simple. Government simply wants to have control over what happens in our institutions of higher learning. And that is what is very worrisome, because it is totally unnecessary and is only going to engender a lot more of what we are seeing at the University of Education, Winneba.
Doctor, I'll have you hold and come to the studio. Now, one of the arguments I've had one of your colleagues make is the fact that, I mean, we all know how the academia is able to write articles and just criticize government, you know, freely. And he says that all of this will bring a culture of silence and make sure that lecturers are now scared to criticize government. Lecturers cannot even write or critique government objectively and all of that. And I don't see that happening because, of course, how would that happen? You still have your pen, you still have your paper, you still have your brains to write your articles. How will that happen?
Great. What it is that my position as a lecturer is a position that I owe to an appointment by the University Council. If I am supposed to be promoted from lecturer to senior lecturer to associate professor to professor, it has to be determined by the appointing authority.
Okay.
And so if, for example, I am the one criticizing government, and then the government is the judge over whether or not I get promoted from one level to the other. It is not, we are not saying that the people who are going to be there are going to be such colors that they may not be considerate in terms of the fact that indeed you have been academically excellent in terms of what you turn out. But we cannot also rule out the fact that if government has majority of members of council, and then I am a critic of government, and that council sits to evaluate my promotion policy, my promotion documents, what is the guarantee that I'll get judgment when you go to a court that is presided over by somebody that you are going to court against? And so, in all honesty, we think that the current system is fair enough, provided government would stay away from influencing the decisions of councils, would want to, and even in the current states, what is happening in Winneba, what has happened in KNUST, what has happened elsewhere, you would have realized that UTAC has been pointing fingers at government in terms of academic interference or political interference in the autonomy and the academic freedom of the universities. Okay. And so it is not time. The timing is wrong, all put together. Irrespective of the fact that we've not been consulted, we think that the timing is equally not appropriate because the circumstances surrounding KNUST, UEW, some other telecom university where the president gets appointment from the Ministry of Information. I mean, we think that it's about time we allow the systems as established by law to function and to function correctly. If we want to gag the universities by bringing in government appointees to take control of management of the universities, that is where the challenge is going to come from. And like Dr. Apak rightly said, UTAC cannot duly represent GAWA, which is the administrators. Neither can we truly represent TEU. Neither can TEU represent UTAC. And so all of these unions are major stakeholders in the governance of the university. And so we don't expect that it is time to be thinking about, I don't know what the motivation is because we've not been engaged and we cannot guarantee what the motivation of government is in trying to push this through. But we think that the timing is wrong. Many of the provisions within the draft bill are irrelevant, and that what currently pertains is worth working with and ensuring that government does not step beyond certain bounds in ensuring that what happens within the universities happen for what is right for the universities as pertains across the international community.
All right, so I think it will be fair to bring in the government and specifically the communications director of the Education Ministry, who's been explaining why this bill is very important. Okay, so we'll get that shortly for you and hear government's own side. But one of the explanations I've heard from the Education Ministry is the fact that this is just a draft proposal and university lecturers have been asked to bring in their inputs before it will be laid in Parliament. I mean, you still have the opportunity to make few changes, or if you want the whole thing to be changed entirely. I mean, why are you resisting it?
Reality is that we've had experiences of government springing on us some surprises, so to speak, in terms of many of its policies in relation to education. For example, you hear on a media platform that government is going to introduce free senior high education, double-track system. UTAC formally wrote to Ministry of Education asking for the policy document for free SHS and the double-track system. As we said, we have not gotten a copy of the policy document. Note that 2021, universities are going to receive graduates from the free SHS and the double-track system.
Right.
That is the kind of thing we are talking about.
Okay.
So government wants to go into probably doing some changes in the educational policy. Major stakeholders ought to be consulted at least. There should be some common grounds at which a bill can come from. You don't spring a bill on UTAC and expect UTAC to, okay, if UTAC says no, what happens? We cannot guarantee that government will not go ahead, put this before Parliament, has majority in Parliament, and will pass the bill, and then we will have to swallow what government wants us to take.
Okay.
And so these are some of the things. So at the inception of the bill, if major stakeholders are consulted, there are some baseline agreements within which the bill may operate. Then, of course, we can agree that at least we made some input into the draft, but these are not the things we said as we were conversing, and so changes should be made here and there. We know that as a matter of process, the bill would have to go to the Committee of Education in Parliament. The committee would have to engage major stakeholders, of course, including UTAC. When it came to the conversion of technical universities, polytechnics to technical universities, the committee invited UTAC. We were present to make our submissions. Whether or not they were considered is another thing. After all, the bill is passed, and then the technical universities are in operation.
Place.
And so that is where we have a problem. And so from the inception of the idea through thinking through who are the people the ministry thought through with, if major stakeholders such as UTAC wasn't part of that thinking through process, those are some of the key challenges.
But you agree that some of your colleagues actually do not have a problem with this bill, and that's what I want to engage Dr. Apak. Doc, some of the lecturers themselves really do not have a problem with this bill, except, I mean, with the bill in its entirety, except for the portions that they've, for instance, clause 5 to clause 12 is where we've had some of the challenges. One of it is the fact that there's supposed to be an ad hoc committee, and they're claiming that the membership of that ad hoc committee, the bill is silent on. But you are saying that government should abandon a bill that they think will better manage the public universities?
Well, I don't agree with the proposition that this bill is going to be the best way to manage our public institutions. Going through what I have seen, if that is what is going to come to Parliament, I am yet to see anything in there that is an improvement over what is already in existence. If you ask me, this that I am seeing is actually very deficient, because, you know, the life of every university revolves around students and lecturers. Management, in this case, council, is there to make sure that the activities of students and lecturers go on, in this case, teaching and learning. So if you have a bill that is being proposed to give control over what goes on in a public institution to the one component of the system that is only there to coordinate, then clearly we have a problem. I mean, what is the justification in trying to reduce the number of council members, trying to cut out representation from stakeholders, and then increase the numbers of those who are going to be appointed by government? And that in itself, to me, is a very wrong approach because it simply cannot be justified. And I have not been given any reason to demonstrate that what we currently have in terms of the autonomous acts governing our public institutions being deficient or not being up to par in addressing challenges of those institutions and therefore warranting this proposal that we are discussing. To be honest, I think it is needless. The educational sector has a lot more dire and immediate challenges that I believe as a nation we should be spending time, energy, and resources discussing about the way forward, rather than focusing attention, time, and resources on something that I don't believe can be justified under the circumstances.
Well, let me pick this communications director for the Education Ministry. I'm told is ready. Let's listen to how he explains that this bill is very, very important and we need it right now. We cannot even wait, or we cannot allow the old laws to rule our public universities as it is, and that we need this new law.
If you look at the law that governs KNUST, it is a law that was enacted in 1961.
Okay.
It is almost outmoded. Mm-hmm. It cannot be a law that in the 21st century you can use to govern a public university. And that is why when the KNUST incidents happened, everybody was saying what he or she thinks about the interpretation of the law that governed KNUST. Okay. There wasn't a clear-cut roadmap as to how dispute resolution could even be resolved. In fact, if you check the KNUST law, there is nothing like dispute resolution. And so it means that the framers of the law in 1961 did not anticipate that there can ever be a day whereby there will be dispute and how the university or if like government can even intervene. And so we felt that it is right and apt for us to bring about this law. If you go to University of Ghana, there have been some instances whereby, if you like, the president will have to appoint the chancellor. But same cannot really be said about KNUST as far as the act is concerned. In KNUST, the council will have to meet and appoint a chancellor, if you like. You understand? So the inconsistencies have been very enormous, and government felt that for us to bring some amount of uniformity as far as the regulations of our universities are concerned, so that if you go to University of Health and Allied Sciences today, if you go to KNUST today, if you go to University of Ghana today, wherever you stand, you know that there is one law that governs all our universities. Okay. Because, you see, if you go to KNUST today, they can tell you that for you to be able to attain associate professor, you may have to publish, for example, say 10 papers. University of Ghana will tell you that you may have to publish about 20 papers. You see the discrepancy as to how awards are even awarded. Okay. You are in KNUST, you get 10, but the University of Ghana 20, yet the same award will have to be given to you.
So you heard Vincent Assefoa, he's the communications director at the Ministry of Education, and he makes it, the point clear that government is concerned with the inconsistencies in the current laws, and that, and you made it clear that, I mean, what transpires in University of Ghana will not be the same at KNUST. They have different ways of doing their things, and he says there are inconsistencies, so they want all the universities to have one law that I mean, that makes sense. And more importantly, he makes a point that the old laws do not even deal with dispute resolutions, and that the framers of the law did not even think about that, so that was not defined in it. And I also heard him talk about, if you even talk about academic freedom, it's not even defined anywhere in the laws available. So they want to actually bridge those gaps with this new bill.
Well, unfortunately, it doesn't. The draft bill doesn't satisfy the condition as he expresses. What it is that there are a number of regulatory bodies, including National Council for Tertiary Education. He talked about concepts of promotion where, for example, a lecturer in University of Ghana may require to publish 20 papers before you are promoted to, say, associate professor. In another university, you may be required to. There is also a policy that is already been worked on. It's just yet to be adopted, and it's called harmonized or conditions of service, which include the number of papers required, at least the minimum and maximum for promotion amongst all the public universities. And so the systems, the regulatory bodies are there, and many of these things that he talks about are the things that these regulatory bodies are supposed to be handling. And in any case, if a law was passed in the 1960s, and today government feels otherwise, that that law needs revision, why do we have parliament? The Ghana Museums and Monuments Board Act was a decree made in 1969. That is what rules. And so if we feel that a law establishing one of the universities is out of date in terms of the provisions, what prevents us from making proposals for amendments or for some revision by our parliament in respect of those elements that government feels need to be dealt with within the said institution?
Okay.
And so why will government pass a bill to establish a university of energy and natural resources and expect it to function in the same way as a university of allied health sciences? We don't get it.
Okay.
And so those are the challenges. If a law is outlived its usefulness, we have a parliament. We can revise the laws, we can make amendments to the laws that establish the universities, look at the mode of operations, what is lacking, and then we can fill in the gaps rather than this blanket thing which seriously doesn't seem to address any issue at all, given the existing regulations.
Well, government says that it's just a proposed bill, and after all consultations and inputs, it will now lay at the doorstep of Parliament. Now, the minority intends to resist it with all force when it gets to Parliament. When we come back from this break, we'll be looking at how the minority intends to do this, looking at their numbers, knowing that the majority outnumbers the minority in Parliament. Then we'll also be interrogating how the university teachers intend to battle this out. Please stay with us. You're back on PM Express. Thank you so much for staying with us. And in the studio with me is Dr. Samuel Nkuban. He is the Vice President of UTAG at the University of Ghana campus. And I also have Dr. Clementa Park, who's been joining us live in the discussion. I also told you that the Communications Director of the Education Ministry was supposed to be part of this discussion. Last minute to the discussion, he called and said, he had called from the powers that be that he shouldn't be part of this communication. So you be the judge for yourself. It's not like we brought a one-sided panel, but this is what happened. But we've also been able to acknowledge that in the last few days, we've had some chaotic moments with some universities. We can talk of KNUST, what happened, and we can even talk of the University of Education Winneba. That issue is still even pending. It's not been dealt with. And all of them have been the Vice Chancellor. We want the removal of the Vice Chancellor and all of that. The question that comes in, even with the current laws, the Vice Chancellors are still nominated by the President. And hardly have I seen the Council rejecting any Vice Chancellor that the President has appointed. So for me, this really won't make any difference. But the point is, if these issues you're raising, in case or in the event that they are amended or they are revised, for instance, Clause 5, which talks about reducing the number of member of council from 15 to 9, and if they were revised to suit you, would you agree that this bill is important for the universities?
Well, I think that the issues that we have experienced in the last couple of years, KNUST, University of Education Winneba, which is still pending, they have nothing to do with the statutes and the laws that establish those universities. Okay. If it were the case, I think that many of the cases, particularly the case of University of Education Winneba, have been because of the blatant disregard for the law that established the university and the statutes of the university. That is why we are where we are with University of Education in Winneba.
Okay.
For example, if the law does not permit you to be promoted to the next rank when you are a year away from retirement, I don't see how that changes when you become council chair and get yourself promoted 5 years after going on retirement.
So if the bill is even revised, you still don't want it? You still want the old laws to
The reality is
persist.
that we have not been engaged as to why the need to change the old laws that govern our universities. We don't see what is the case that doesn't make the Act of the University of Ghana, for example, a credible law in terms of governing the University of Ghana.
Okay.
Because it's a law that, like the gentleman was talking, the ministry's gentleman was saying that the laws have outlived. University of Ghana's law was revised. What prevents us from doing same to other universities where we feel that this section of the Act needs revision, this addition needs to be made in order to make the university a more... And so, generally, I don't see, until we are convinced that the acts that govern, that establish the various universities, the statutes governing those universities are not in... They do not contain provisions that would inure to the good governance of the university system. I'm not sure this draft is good enough as...
so you will push hard to ensure that it doesn't happen?
Well, we wouldn't say it wouldn't happen. And we know that government has a way.
So you need to engage government?
Government needs to engage us.
All right.
If we are not engaged in terms of... Because in passing a law of this nature, certainly it has to go to the Committee of Education. Like I said, the committee has to engage stakeholders. Stakeholders will make inputs. If the stakeholders say that the law is not worth, I don't think government should be pushing too hard.
Doc, the final bill will come to Parliament. How do you intend to resist it with all the force you talk about?
Well, it is the right of government to propose laws. As you know, by our constitution and by current arrangement, most laws or bills that come to the legislature usually come from the executive. Now, we as a responsible minority, we would make sure that we point out the flaws and the fact that this is not needed and that there is no real present danger that should warrant the nation expending time, energy, and resources to pass a public universities bill when there are much more challenging situations in the educational sector. We will rather, the resources should be channeled to host a national forum for us to look at the best ways to reposition the free senior high school policy to deliver on what it is meant to be. So yes, government definitely has the majority in Parliament. They have the majority on the Committee for Education. But I believe that those of us who are stakeholders can also make the case to justify why this is not an expenditure that the public should bear when government has not demonstrated any pressing need to support this proposed bill that it is bringing forward to Parliament, if that is true.
Well, Doc, I'm grateful for your time on PM Express, and we'll be monitoring events, and Trust JoyNews will bring you all the updates as it unfolds. Many thanks to Dr. Samuel Nkuban, who is Vice President of UTAG on the University of Ghana campus, and many thanks to Dr. Clement Apak, who is Deputy Ranking Member on the Education Committee of Parliament. Many thanks to you at home for watching. My name is Aisha Ibrahim. Have a great one.